Welcome back. I'm Tomas Rahman. In this next chapter, we're going to be taking a look at an innovative approach to resolving disputes, especially those headed for or involved in the formal complaint procedure. Now, that utility box right there was placed here on my friend Amy's lawn. This is what it looked like back then. Now, Amy called the utility to complain, but she was told that this was the most accessible location for the utility. It was also the safest, allowing ample room for street traffic to move around parked utility trucks. Moreover, the utility has an easement for this location in order to better serve the community's needs. Amy asked the utility if the box could be moved to another safe and accessible location on the property, like here, where it could be hidden with vegetation and not detract from the appearance of the home. Well, the utility told her that yes, she could have the box moved, but it would cost a lot. $50,000 was one estimate, and Amy would have to pay to have it moved. Well, Amy was frustrated. She didn't want a box in the middle of her lawn, but she also didn't want to be faced with an unexpected financial burden. When Amy looked over the CPUC website and discussed her problem with the Public Advisor's Office, they suggested that instead of filing a formal complaint and taking more time with her problem, not to mention incurring more legal costs, that she instead consider using a no-cost approach called Alternative Dispute Resolution, or ADR. Now, ADR offers a variety of dispute resolution processes: facilitation, early neutral evaluation, settlement conferences, and mediation. To help us better understand alternative dispute resolution and how Amy used it, let's go to our ultimate solution finder, Barbara Rodgers. Hi, Barbara.
Hi, Tomas, and welcome to Chapter 4, Alternative Dispute Resolution. To help explain ADR and ways to take advantage of this procedure is Ken Koss. Ken is an administrative law judge at the CPUC. Welcome, Ken.
Hi, Barbara. Hi, Tomas. And you know where my office is, yes?
I do. I'm on my way up, Ken.
Well, let's begin by discussing what alternative dispute resolution strives to do and how someone, say in Amy's case, could benefit from choosing this route.
Glad you asked. Alternative dispute resolution offers both parties ways to settle a complaint through a negotiated agreement. ADR focuses on each party's basic interests and ways to accommodate them both. The ADR program is conducted through our Administrative Law Judge Division. Trained in the different ADR procedures, select administrative law judges act as neutral third parties in the program. ADR is a voluntary procedure, meaning that Amy and the utility both agree to participate in the process. Tomas mentioned 4 options within ADR: facilitation, early neutral evaluation, settlement conferences, and mediation. For our purposes, we're going to look at mediation, since most disputes are resolved in ADR through this process. Mediation involves both sides conferring with a trained mediator. The mediator holds joint and separate discussions with each party. Amy and the utility company get to voice their concerns privately with the mediator, as well as listen to one another's side in the joint session. Mediators remain neutral through the session. They do not provide legal advice, but rather keep the discussion open and encourage both parties to suggest settlement options and to consider each other's real concerns. Either party may stop the discussion at any time, or ask for a delay so they may seek legal advice or consider the other party's suggestions.
Hi, Ken. Thanks for inviting me to listen in.
Hi, Tomas. My pleasure. We think the ADR program is a way to resolve formal complaints more efficiently, and we'd like folks to know more about the program.
And those who engage in ADR are asked to do so in good faith. It's a good faith effort on both sides to reach an agreement.
Absolutely, which is why ADR requires confidentiality. This ensures that both parties can lay out their core interests and not risk that this information be used against them later in a legal proceeding.
I don't mean to be a spoilsport, but wouldn't an individual like Amy have the most to lose by using ADR? I mean, after all, utility companies have a lot of legal help and protection.
Which is why we're here. In ADR, we strive to ensure that all viewpoints are heard. And it's very important to remember that mediation is confidential. Unlike a formal or legal proceeding, settlements in ADR incorporate the interests of both sides, so Amy's needs would be represented.